What is up, guys, and welcome back to another contract video with my little paralegal here, my paralegal Mila. But she likes to take a lot of lunch breaks, so she's always sleepy in a food coma. Mwah. Baby, sorry, didn't mean to disturb your beauty sleep. Anyways, you may have seen my other video about cash contracts in real estate where I pointed out the most important clauses in these contracts. Today, we're going to talk about assignment of contract. This probably rings home for you guys who are in wholesale in real estate, meaning you find a property at a discount and then during a grace period, which is called inspection period, you try to find a buyer and sell it for hopefully a big difference to that buyer. If you want me to make a video on wholesale specifically and tell you guys how to get in it, especially as a woman, it's a male dominated scene, let me know. I'm happy to help you guys out. If you need more info about contracts, how to go about the process, how it works, leave it in the comments down below or find me on Instagram. I always love to hear from you guys and I always make an effort to answer y'all. Well, let's get into this. What is an assignment? Assignment means that you are selling, or somebody sells their rights from another contract they have to a buyer. So pretty much they transfer all the rights and obligations from that contract that they have to somebody else. Pretty simple, pretty standard. I think most of you guys have heard about assignment of contract. That's why you're here. The first thing, there's many parts to this assignment, but I want to highlight a couple of very important clauses. And the first clause that I want to highlight is about the earnest money deposit. Just as with the seller, as a sign of good faith, you put money in escrow to show that you are really interested in buying this property. The same goes for the buyer. Now, here's a couple of my advices. First of all, make the earnest money deposit of the buyer higher than yours. And we're getting to the point why that is important. But first, we usually put as after how much and to who the earnest money has to be deposited. We include that the contract is not binding until the escrow agent has received the earnest money deposit. Now, this is important because in the past we had incidences where somebody signed, but then first of all, they didn't put earnest money deposit in and we're like kind of slacking and in asserting it. Then we were waiting for them 1 week to, hear back from them, see and move the process forward, but they just ghosted us. You really want to make sure that you get them earnest money deposit in. And if we don't get it in, that's a sign for us to keep marketing, because we stopped marketing when we found that buyer. We thought we're good, we're ready to go, but we weren't. We actually had to get an extension from the seller. It was messy. Make sure you include it, make sure that the buyer knows that you're gonna keep marketing that property until the earnest money deposit is in. Now, secondly, also under earnest money deposit, you want to include a clause that allows the escrow agent to replace your earnest money deposit with the new buyer's earnest money deposit, so that you get your cash back and you're liquid again and you're $0 into this transaction. So pretty much you're risk-free into this transaction. Very important clause to include. Would highly recommend that as soon as that escrow money is in, you got yours out and you have not only gotten your money back, but also you're risk-free into this transaction. The most important clause that I can just triple highlight in this case, and this is probably the highlight of this video, is the following clause. And let me first give you a little story. We had this great property and we had it at a great price and we marketed it and there's a lot of interested people. And we had this one gentleman who was very interested in this property and he was giving us $10,000 more than any other offer. We said, for sure, thank you, let's sign, let's get this going. We signed the assignment, the earnest money deposit at the time it was $3,000. We got in, we were ready to close. We were actually really hoping for this transaction to close soon, within the next 3 weeks. And after 2 weeks, the buyer tells us, I can't buy next week, I need more time. We're like, what do you mean? So yeah, I need more time. We're like, how long do you need? Yeah, I don't know. And he ghosted us. We still had time until our closing date with the seller, which we usually put. Another tip, you want to put the closing date with the assignee way before the closing date with the seller, so you buy yourself more time in cases like this. But in this case, the gentleman ghosted us. Pretty much after 6 weeks of dragging it on, trying to reach him, we knew we had to sell this property to somebody else. So we sold the property to somebody else for $10,000 less than original. And we're like annoyed. This person caused us $10,000 damage. Now we had to set a discount. We were looking bad in front of the seller. So we wanted that $3,000 that he deposited as liquidated damages. So we reached out to the title agency and we said, can you please release that money to us? And they're like, yeah, if you can get the buyer to agree. And we're like, why? Why does he need to agree? It's like, because you didn't have any agreement. It's just there. We don't know. We can't just release it to you. So we're like, what did we do wrong? What we did wrong was we did not have this clause in our contract. And again, put this clause in your, pause this video, copy paste this clause and put it in your contract, because it's gonna save you a lot of money in cases like this. This is the clause. If assignee fails to fund and close on the specified date herein due to no fault of the seller and or assigner, and clear and marketable title is in place, all deposits will be considered liquidated damages and are to be released to assigner immediately without the requirement of any further instruction to escrow. Assignee agrees that no additional release of deposit or cancellation of contract will be required. I double it down here on that because it was so important. The important words are without further instruction to escrow, and or, I did a double, assignee agrees that no additional release of deposit or cancellation of contract is required for that deposit to be transferred to us. Include that, and when you tell your title agency to release the deposit to you, they will without any further questions. Now, how did the story end for us? We did get the buyer to agree to release some part of it to us, because otherwise this money would have been in escrow forever, because for him to get it back, we would also have to agree for the money to be released to him. So save yourself a lot of time and a lot of issues with this clause. Shortly and briefly in here, I'm just highlighting the best clauses, but of course the assignee gets his money back if the seller or the assigner can't close. Of course that's in there, but I wanted to highlight the clauses as the assigner, which are important here. Now, one clause reads, the assignee agrees to indemnify assigner against any loss, claim, damage, or expense assigner may incur because the assignee fails to perform the assumed obligation on a timely basis. So pretty much, if the assignee fails to perform whatever obligation is in the purchase contract, he agrees to hold us harmless against the seller. So we want a liability release against the seller from the assignee. A second very important clause, and if you guys are realtors, you are definitely familiar with this because it's similar to a non-occupancy disclosure that you usually request from a seller, is pretty much that. And it reads that the house is being, or the property is being bought as is, and that the assigner has never occupied the property and has no knowledge of its condition nor of any repairs required. Assigner is not liable for any related issues, and assignee agrees to hold the assigner and its agents harmless for such. You're marketing the property and you said it needs a roof and it needs maybe floors, and then the assignee buys it and finds that there's mold in the ceiling. You didn't disclose that as the assigner, but also if you didn't know about it, you have never occupied the property, you couldn't know about it, and usually the assignee is responsible to do his due diligence. But I would always still include that part. Now, what I forgot to mention earlier is that we usually don't give our buyers any inspection period because that's not the norm in wholesale. We always encourage our assignees to perform any inspections before they sign a contract, so just that you know. Also important, and that's something that I want to mention here, but also have a side note to, is that the clause we include that the assignee acknowledges that the property is being purchased with any all open permits or expired permits, and that such shall not be required to be closed by assigner prior to nor after closing. Assigner and seller shall not be held liable for any open expired permits, either prior or post closing. So usually, and I want to put that here, this is the clause we have in the contract, but we are also conscious that we want to add value to the marketplace. Now, we do promise the assignee free and marketable title. If there are permits on the property, especially if there's monetary fines, these are usually paid by the seller. If they're expired or open permits on the property, we usually make an effort, us as the assigner, to close those permits for the buyer, or work with the buyer to close them, or work with the buyer to take them over when it makes most sense. So I always want to encourage you guys to add value to the marketplace by making this transaction as smooth as possible for the seller and the buyer. At the end of the day, both of these parties are your clients and your customers, and you have responsibility for them, right? You want them to have a good experience with you, and you don't want to just get the most money and then exit the conversation. You do want to be there for them, both sides, and that's what we're proud of here at Extra Holdings, at our company. We do want to make it the best real estate experience they had for both parties, and our reviews speak for it. So little shameless plug here, but we're very proud of this. So I encourage you guys to do the same. Don't just leave people to their own devices. They're not gonna come back to you. You wanna provide value. All right, let's move on. There's not much more. Of course, you wanna make your contract non-assignable. I think most of you guys have that in there. I just wanted to emphasize it because it is important. You don't wanna have a chain of wholesale going on unless you consent to it and know about it. Now, what I mentioned earlier with the earnest money deposit is that you or we include in our contract that we can continue market the property until that money is in. And here in that clause, I explicitly stated again that we reserve the right to continue to market the property until everything, all contracts have been executed in writing and the earnest money deposit is in with the escrow agent. You always want to be on the offense. You don't want to rely on a buyer until he's proven himself serious. And then of course, we always include that the assignee agrees to refrain from contacting the seller because we're the person brokering the transaction. It's just kind of a warning statement in here. I did not include a consequence, but I could. But you always want to, make sure that they know that you're the person to talk to. Lastly, and I think that's also standard in wholesale, the assignee, aka the buyer, usually pays all closing costs, but you want to state it explicitly. We have it, assignee understands this is one closing and that assignee is responsible for all closing costs. Just to be clear and good on this. This is our simple, I think, 3-page assignment of contract. Again, always consult with a real estate attorneys. These are just some tips that I wanted to give you, and I think they could be valuable for you guys, but always, for liability reasons, please don't sue me. Ask your attorney before you completely rely on my tips blindly. But I hope you guys enjoyed this video. I hope this brought you some value. I love making these videos for you guys. Let me know in the comments if there's something else you want me to talk about. I know a lot about real estate, business, and law, and I'd love to share more with you. I love you guys so much, and I see you in the next one. Bye bye.